I will talk about not all topics covered by our research, but rather 2 topics. And after a short introduction, I will deal with recognition of foreign public documents in civil proceedings, mainly before courts, but that same applies to the notary public as well. So I would say procedural aspect. And on the other hand, I will deal with substantial issues in all classic private international law issues, formal and substantive effectiveness of actions, legal actions or acts contained in foreign document. So let's start with the introduction. There's no need to emphasize that, as we could hear, that the issues of recognition of public documents are not only technical ones, but fundamental ones. But I will start with historical argument, and history teaches us that documents have great significance in civil proceedings. And on the other hand, history also shows that use of foreign documents in civil proceedings is not the discovery of our globalized world. Because, for instance, legislation from 19th century also regulated the recognition of foreign public documents, though the importance of the use of foreign public documents is significantly stronger in our world of East, cross-border movement of people, goods, and etc. And especially for Serbia, it's of the importance because many Serbian citizens are living abroad. And of course, there are foreigners living in Serbia as well. And that reflects also bilateral perspective, namely Serbia is a member of treaties with virtually all neighboring countries when it comes for the liberalized regime of recognition of foreign public documents, and with with a number of countries that are traditional or great trade partners. 2 basic issues I'm going to deal with are, and from the perspective of civil proceedings, are recognition of the foreign public documents and formal and substantial effectiveness of acts contained in the documents. So I'm going to first deal with this procedural issue, and to start with that, some words should be said about the notion of recognition of foreign documents. Namely, in Serbian scholarly writings and in statutes, the recognition of foreign documents is rather unknown figure as such, because recognition is traditionally associated with recognition of foreign judicial decisions. So one might ask and could ask if it's the proper name of the term or the concept at all. But from the proper perspective, we could speak about recognition of foreign public documents, namely recognition of probative value, evidential value, as procedural effect. And the starting point is the general rule of Serbian civil procedure, common rule in contemporary Europe, and I'd say world as well. That's the principle of free evaluation of evidence. So by statute, all evidentiary items have, as a rule, no probative value per se. So the judge or the court panel is free to assess every piece of evidence. But there is one major exception, which is rather traditional. That's probative effect value of public documents, as we could hear as well in Serbia. Public documents establish rebuttable presumption of so-called truth. Private documents, on the other hand, have no evidentiary value. So the free assessments of the court applies, which means that there is no possibility of recognition of foreign private documents, because private documents have no nationality, and it was affirmed in case law as well. Supreme Court ruled that foreign, so private documents enacted abroad are just like Serbian private documents without have any prescribed documentary value. And previously mentioned law on legalization, which was enacted as a Yugoslav federal statute back in 1973, tries to define the notion of foreign. So which public document should be regarded as foreign. According to Article 3, paragraph 1, foreign public document is one issued abroad. So it should be used or following that provision follows territorial approach. The proper or correct interpretation is that foreign public document is one issued by foreign authority or by person acting under foreign authority. So sovereignty approach is proper one, because we can imagine that foreign consul in Serbia enacts or draws some public document. It should be undisputed that it is not a Serbian public document. So in coming to autonomous Serbian legal regime, so it applies when there is no bilateral or multilateral treaty in force. And as we could hear from colleague from Zagreb, in Serbia as well, two statutes are of the interest or relevant. So that's the Civil Procedure Act. Current Civil Procedure Act is enacted in 2011, and law on legalization, etc., as inherited Yugoslav statutes. I would say just brief on a historical background. That's Austrian influence on our civil procedure, namely in Kingdom of Yugoslavia, which was formed after the World War I. All Austrian civil procedural acts were adopted. I should say that was the reception of Austrian law. And after the World War II, even that the pre-war legal system or order was abolished, new procedural courts were enacted, but the Austrian approach was retained, and it's still retained in present concept of Serbia. And that means that we have a general rule and which demands for two conditions for recognition of foreign public document, that is reciprocity and proper legalization. As we could hear also again from colleague from Zagreb, reciprocity means factual reciprocity, so there is no demand for formal act of reciprocity. And in addition, in Serbian literature, it was advocated to apply by analogy the concept of presumption of reciprocity, namely for in matters of recognition of foreign judgments, reciprocity is in principle the condition for recognition, but it is established as presumption of reciprocity, and it is argued that this concept should be here applied by analogy. And when it comes to legalization, it means consular legalization or full legalization, and that is according to the law of on legalization, certification of authenticity of the signature and the seal. so it doesn't cover the competence of the issue authority or the procedure itself. And the competence for the legalization is divided. Let's say it's alternative, so diplomatic or consular mission in the state of origin, or the document or Ministry of Foreign Affairs is also competent to make the legalization. There is a special rule according to the law on legalization, that's liberalization based on reciprocity. Foreign public documents are exempt from legalization if based on, we should say, factual reciprocity. Serbian public documents are likewise exempt from legalization in the state of origin of the document. And of course, and I won't go in depth, there are bilateral and multilateral treaties in force in Serbia, as I said previously. Numerous bilateral treaties, mainly legal aid treaties, abolish legalization on any other formal requirement for recognition of foreign public documents, but the scope of application is rather different, and the fact that a good number of treaties goes back to the socialist Yugoslavia should be taken in account as well. And I would maybe ask colleague from Zagreb to after comment one specific issue, because we share the same treaty with Bulgaria that is inherited from the socialist Yugoslavia, namely in that treaty, just a second, the exemption from legalization applies to public documents drawn up or issued by a court or another state authority. And such provision raises question whether notarial instruments are also covered, because notaries are both in Serbia and Bulgaria are not state authorities in strict sense, rather public officers appointed by the state. Why is this question peculiar? Because that treaty was dates back to 1956. In that time, I think, that's my opinion, there was no practical need to refer expressly to notarial instruments, since under socialist legal system then prevailing in Yugoslavia, the institution of notary did not exist. It was reintroduced after the fall of Yugoslavia in successor states. So the question is for me, if we could apply this treaty by analogy and take into account this historical background and current situation also for notary instruments. And of course, Serbia is member of Apostille Convention, and apostille in Serbia is given either by a competent basic court, municipal court, or Ministry of Justice. That takes me to the second part of my presentation, and those are classic private international law issues, because the fact that one foreign public document, for instance, is recognized in this procedural sense, it does not mean automatically that effectiveness, substantial effectiveness, is recognized as well. So two issues arise from this basic private international law issue. So issue of form of validity or determination of law applicable to the form of the legal act, and issue of substantial validity of the act or determination of the law applicable to the content or the substance of the legal act. Serbia has not yet recodified its private international law. That means that for Yugoslav federal statute, private international law from 1982 is still in force. Private International Law Act is the rather nickname of this piece of legislation. It has long title, but it's common to refer it as Private International Law Act. There was there was attempt to recodify private international law in Serbia. The working group had drafted the new piece of legislation, but it failed. We don't know what were the reasons. It never came close to the parliament, and I'm rather skeptical of the future of that project. So we'll stick with the old Yugoslav Private International Law Act, and specifically when it comes to legal acts concerning real estate, law on real estate transfer is rather significant. We will see why. As a general rule, for the formal validity of the act, Serbian law, Yugoslav law, follows traditional liberal approach as a general rule. So there is alternative connection, lex causa or lex loci actus, and the scope of application of Article 7, which is provision for the law governing the formal validity of the legal act. It applies to all legal acts, thus including power of attorney. So all legal acts in German sense of Rechtsgeschäfte. And rationale is quite known. That's in favorem negotii principle, maintaining the validity of the act, and on the other hand, safeguarding the legal certainty. Article 7 of Private International Law Act makes no mention of acts inter absentis, but according to the prevailing view in legal theory, this provision should be interpreted in line with comparative concepts of multiplying alternative connection factors. So one such legal act is formally valid if it's formally valid under lex causa, or alternatively formally valid according to the law of the offerer or the offertee. But there are special rules for acts concerning real estates. And it is undisputed view that form of the act, so contract as well as power of attorney, is exclusively governed by lex rei sitter. So if real estate is in Serbia, Serbian law is applicable to the form of the contract of power of attorney. And when we speak about the contract, a legal form is notarial form, notarial deed, or we're saying solemnization, and that's also Austrian product. So that means that parties are drafting the contract, but it is confirmed by notary public and then becomes a public document. And that is undisputed view, but that's not the end of the problem, it's the beginning of the problem, because then the issue of substitution arises. So the major problem is it possible to apply substitution theory? That would mean that, for example, Serbian notarial form is replaced by foreign functionally equal form, for example, by Croatian notary public. Is it admissible or not? And it's worth mentioning that Article 4 of Law of Real Estate Transfer provides exclusive territorial competence of notary public in whose district real estate is situated, and if contract is concluded before territorial incompetent notary public, the contract is null and void. There is a dispute in contemporary legal theory. According to minority view, there are no obstacles for applying substitution theory, because This view argues that Article 4 of real estate law on real estate transfer concerns only territorial, so internal competence, not international. So there is no obstacle to apply substitution theory. Of course, substitution is only possible if foreign form is functionally equal to Serbian notarial form. And in my example, we should agree that Croatian notarial form is functionally equal because of Latin notary nature. According to prevailing view, the substitution is unadmissible, and there are two lines of reasoning. According to one, cited Article 4 is overriding mandatory provision, and according to another line of reasoning, which applies traditional German theory of substitution, the cited Article 4 is barrier to the substitution. And this German approach is based on two-step test. So first step is to assess if domestic norm, which provides for special form of the legal act, is opened for substitution, and that assessment is based on interpretation of the provision in matter of goals, rationale, and etc. And second step is, of course, if it first question is answered affirmative, second step is to see if, and to assess to see if foreign form is functionally equal. Against that background, not only that Article 4 provides nullity of the contract if it's concluded before incompetent notary public, there are also other provisions that suggest that in legislative view, substitution is not admissible. For example, Serbian notary public has the duty to transmit the contract by special online platform to the public land registry, or it has duty to submit the contract to the court responsible for maintaining the special register of such contracts, aiming prevention of double sales, etc. I think that foreign notary public is not capable for fulfilling these duties, and if we would say that substitution is admissible, the goals of these provisions would fail. So in concurring with prevailing view, we could say that substitution of domestic Serbian notarial form is not admissible in matters concerning real estates. And sorry.
Professor, sorry, please go to the conclusions, okay? Because it's 6 minutes.
Yeah, I'm sorry. As applicable law for the substance of the legal act is concerned, there are general rules, primarily subjective connections, so choice of law, party autonomy. Secondarily, objective connections, albeit subject to escape clause. So there are, for numerous contract defined connection factors, and for other contract connection factor is domicile or seat of the offerer. Of course, there are special rules for acts concerning real estates as well. So according to Article 21 of Private International Law Act, there is Lex Res Sitte is exclusively applicable. And at the end, there is no explicit provisions for applicable law to the power of attorney. So in conclusion, I could say that Serbian law provides as Croatian as well as Slovak as well, rather rigid or strict approach when it comes to recognition of foreign public documents, but there are no recorded major issues in the practice, And even though legalization is rather slow process, the fact that Apostolic Convention is in force and the vast majority of foreign public documents fall under the scope of Apostolic Convention, so there are no major issues in practice, as I said. Pro futuro, I'm not aware that any piece of this legislation is to be amended. So in the view of the Serbian legislator, everything is just fine. If that's true, that's true, we should stick with these rules, but there is, of course, need maybe to reconsider this strict approach. Thank you for your attention. I'm sorry if 5 minutes I took your time more, and my apologies for that. Thank you.